Hey folks, this is Corey Kupfer with another authentic business video, RIA Edition. So I wanted to talk about some of the cases that have been going on, mainly with Morgan Stanley, with regard to suing advisors who are breakaways from Morgan Stanley to go independent, and especially after now Morgan Stanley's left the broker protocol. So for any of you teams who are looking to leave wirehouses or other places, or if you are a firm that is onboarding advisors, this will be of interest to you. And what I want to do is I want to just use as an example. So there's a case that Financial Advisor IQ reported on a few days back in Florida with this Daniel Abel and Morgan Stanley. I want to use just the arguments that the lawyers are making in this case as a guide for talking about some of these issues. I'm not commenting on this case specifically. I don't know the facts of this case. I'm not involved in it as a lawyer or otherwise, etc. But I just wanted to use this to highlight some things for everybody to be aware of. So number one, basically what happened was Morgan Stanley sued this guy after he left, claiming that he took confidential information, that he violated the broker protocol, that he solicited clients, went in for a TRO, which is a temporary restraining order to restrict him from using the information and from soliciting clients, was granted the TRO. And then I think I'm recording this on Tuesday. I think actually today there is a hearing on the permanent injunction. What's important here is some of the interesting arguments and how they affect more broadly the issues at hand. So one of the things that they claim is that Morgan Stanley was a member of the protocol, went off from Morgan Stanley's point of view. The lawyers for Abel are alleging that because they were on the protocol when Abel came in and was employed there, that he should have been able to rely upon that, and that when he leaves, the fact that they've gone off the protocol shouldn't hurt him. Now, that's an argument that, frankly, it would be very interesting to see whether a judge buys, but I am of the thought that that will not fly for the following reasons. So first of all, the protocol by its terms allows firms to leave on 10 days notice. So if you're relying upon a protocol, a document, that by its terms allows somebody to go off the protocol, then you either were aware or should have been aware of that fact, and that it wasn't guaranteed the firm would stay on. Secondly, at least in theory, you could have negotiated to get that protection contractually. So in other words, and I've done this, by the way, not at wirehouses, but I've done this at smaller firms a couple of times over the years, where I've said, hey, in the contract that my client signs to onboard there to come in and bring his or her business in, that we have an agreement that even if the firm goes off the protocol, that the client will be treated as if they had protocol protection. As far as I know, Abel didn't have this here in this case, and frankly, I don't think Morgan Stanley or any other wirehouse would likely agree to it. But in concept, that could have been negotiated. And if he couldn't negotiate that, he could have made a choice not to go there. So between the fact that the protocol allows for 10 days notice and the fact that it could have been negotiated, I think that's going to be a losing argument. I'd love it to be a winning argument because it would be phenomenal for the independent advisor movement, but I don't see it happening. The second thing they allege is that he was forced to sign, or that basically the day he joined, an agreement was put in front of him, and he needed to sign it without knowing really what he was signing and having time to really review it, etc. Again, I think that's an argument that will fail. First of all, although because of outside business activity issues, when somebody, in his case, he went from one wirehouse to a different wirehouse to Morgan Stanley, you can't sign an agreement in advance. It would be an outside business activity that would be a problem. You could ask for the form of agreement you're going to ask to be signed, that you're going to ask to sign when you join after resignation, and you could review that. And theoretically, again, you could negotiate that, although there may not be a lot of practical leverage to do so. But the fact that, there are cases out there more in the consumer industry and a lot of regulation around that about, review periods and periods to reject or rescind. That's really much more for consumer protection, where there's a significant uneven bargaining position. And although you may argue here that the wirehouses have a bargaining position over the advisors, the truth is they do have other options, and they're sophisticated people, and they can afford legal counsel to review things. So I don't think that argument's going to fly. The other thing that was alleged is and this is really going to be fact specific, is about the solicitation itself, on whether he solicited clients or not. That's fact specific. One of the claims the lawyers are making that is a claim that I think will get some traction if it's true, is that the information that Morgan Stanley alleges was taken as confidential is available through publicly available sources. For example, names, address, contact information, etc. And in most states, in most cases, if you are able to obtain information from a publicly available source and you actually obtain it that way, this is a key point I want to go back to, that even though it happened to be, for example, on a client list, that it's not necessarily confidential, because by definition, confidential proprietary information has to be just that, not publicly available. So in this case, the facts will determine. Now, if this advisor downloaded a client list, we always tell our clients that anything, listen, forensically, they're going to figure out exactly what you did. You downloaded a client list, if you emailed it to yourself, you put it on a zip drive, you printed it out, everything's digital, they're going to know. So the facts will bear that out. But let's assume that that Abel did not download or take any other information. Then the question is, and what we always advise when we work with breakaway teams, is you don't want to just say it's publicly available. You actually want to do the research, right? Even if you have the client's phone number memorized, my recommendation is always go do the external research, keep a documentation of exactly how you found that through a publicly available source to be able to defend any claims that you took proprietary information. Again, that doesn't work if they have evidence that you downloaded a confidential client list. But that's something there. So that'll be an interesting thing to see how it plays out. And I do think there are potential defenses there in that case, as there would be to other advisors. So that's an area. The other question is, did he actually solicit, which is going to be at the crux of the case. And in most states and in most agreements, the restriction is on soliciting, not necessarily accepting business under the Wirehouse agreements. In some states where there is even if the contract has a non-acceptance clause, there are a number of states that won't enforce that. By the way, California is an outlier in this whole conversation. Very hard to enforce non-solicits of any type there. Although even California has an exception if you've taken confidential information and are soliciting based upon it. But in the rest of the country, in general, a non-solicit is going to be enforceable. In many states, a non-accept will not be. Got to look state by state. This is state by state. But it'll be factual, okay? Did he solicit? Now, what's interesting is, and again, I'm going by the article, what's interesting is the only cases that the defense lawyers claim that they have any evidence of what they call solicitation is the advisor's uncle and two long-term clients who were with him at, I believe it was Merrill Lynch, is where he was prior to Morgan Stanley. So in that case, the first of all, it's to be factual, element, did he solicit or not? Certainly if, I think it's going to be tough to have a judge say that, with the uncle, but let's say the uncle testified that he did get solicited. Then the next question is going to be, let's say they find there was an illegal solicitation of somebody. Then the question is damages. And one of the things that I'm sure the lawyers are going to do is to try to show that these clients would have come over anyway, even without the solicitation. It's my uncle, right? I think that's an easier case. The two older clients, I don't think by definition, by the fact that they had a prior relationship, there's no carve-out in the agreement, as far as I'm aware. I've never seen a Wirehouse agreement that has a carve-out for prior clients for most advisors. So I don't think it will matter much the fact that they were prior clients, because if they were solicited, because that's still a violation, although it may help on the damages side if they can get testimony and affidavit from those clients that they would have come over anyway. So even without the solicitation, so then the argument is that Morgan Stanley is not damaged. So those are some of the issues in the case. This is exactly what we help breakaway teams navigate, figure out how the best way on protocol and not a protocol transfers, how to get out of places like Merrill, Morgan, Wells Fargo, JP, Morgan Stanley, Merrill, UBS, etc. So, and then we help onboarding firms, the existing RIA firms, to onboard those people in the best way, help evaluate the legal information, design the strategy, and put everybody in the best position. So I hope this was helpful for you, whether you're an onboarding firm or a breakaway team. If you have any other questions, you can certainly reach out to us. Our contact, just click through our contact information. It's cupforlaw.com. You get to us there. Give us a call. Happy to answer any of your questions. Pleasure talking to everybody. Take care.